Hello everyone, let's continue where we left. We were on question number 29. We have already completed up till question number 28. Let's repeat this question one more time. The Supreme Court delivered a judgment. The next day, a newspaper adversely but fairly comment on the judgment in an editorial. Would it be correct to say that the editor has not committed contempt of court? ठीक है? He has given his opinion and that is completely fine. So the editor has not made any kind of contempt of court. See question number 29. A court may grant interim measures during the pendency of arbitration proceedings. Such interim measures may include appointment of a guardian for a minor for the purposes of an arbitration proceeding, appointment of a receiver, securing the amount in dispute in the arbitration proceeding, all of the above. The right option is option 4, that is all of the above. Securing the amount in dispute in arbitration proceeding, receiver, and appointment of guardian. Okay, so the right option is option 4. Now see question number 30. Before that, we have a direction that there is a statement against each of these questions. Read the statement and confirm whether it is true or false. Mark the answer as first or second. First for true, second for false. Now see the statements. A foreigner can be appointed as an arbitrator in a dispute between two Indians. The right option is true. First, true. So a foreigner can also be appointed as an arbitrator. Question number 31. There is no difference between arbitration and mediation proceeding. The right option is second, false. Question number 32. The provision of Limitation Act 1963 apply to arbitration proceedings as they apply to court proceedings. The right option is first, that is true. Question number 33. If an arbitral award is not challenged, it is enforceable as a decree. The right option is first, that is true. See question number 34. A conciliator shall assist the parties in an independent and impartial manner in their attempt to reach as amicable settlement of their dispute, may conduct the conciliation proceedings in such a manner as he considers appropriate. Third, may make proposal for a settlement of the dispute, or for all of the above. The right option is fourth, that is all of the above. Question number 35. Conciliation proceedings terminate first by the signing of the settlement agreement by the parties. First, by a written declaration of the conciliator to the effect that further efforts at conciliation are no longer justified. Third, by a written declaration of the parties addressed to the conciliator that the conciliation proceedings are terminated. Fourth, by a written declaration of a party to the other party and the conciliator that the conciliation proceedings are terminated. The right option of question number first is first, by the signing of the settlement agreement by the parties. Question number 36. The maxim injuria sine damnum, here it is written as damno. So the maxim injuria sine damno has been explained in Donog versus Stevenson. Second, Winterbottom versus Wright. Third, Asby versus White. Fourth, Lumley versus Guy. The right option is third, that is Asby versus White. The maximum injuria sine damnum has been explained in the case Asby versus White. Question number 37. The scope of availability wait, the scope of available, and from there availability. So the scope of availability available, available. Why it is so difficult? Availability. The scope of availability of the defense of violent non-fit injuria. First, has been restricted in rescue cases. Second, has been restricted by the Unfair Contract Term Act 1977 in England. Third, cannot be restricted except in cases of consent without free will. Fourth, both first and second. The right option is fourth, both first and second. Has been restricted in rescue cases. Second, has been restricted by the Unfair Contract Term Act 1977 in England. See question number 38. The doctrine of vicarious liability applies when there is the doctrine of vicarious liability applies when there is relationship of principal and agent, relationship of partners, relationship of master and servant. Fourth, all of the above. The right option is fourth, that is all of the above. Question number 39. A Hindu undivided family is entitled to enter into an agreement of partnership with another joint Hindu family, another partnership firm, an individual, neither first nor second. The right option is option 4, that is neither first nor second, means with an individual. Question number 40. The maximum number of partners in a partnership has been provided under Indian Partnership Act 1932, Indian Companies Act 1956, Indian Contract Act 1872, Indian Trusts Act 1882. The right option is first, that is the Indian Companies Act 1956. Question number 41. Which of the following is a strong evidence or test of the partnership? Which of the following is a strong evidence or test of the partnership? First, sharing of losses. Second, sharing of profits. Third, both first and second. Fourth, none of the above. Sharing of bond. The right option is second. See question number 42. As per section 14 of the Partnership Act, the property of a firm does not include all property and right and interested in an interest in the property. Second, secret profits made by a partner or profit or property acquired by a partner in breach of his duty of good faith. Third, property belonging to any partner by use of the same for partnership business. Fourth, goodwill of the business. The right option is second, that is secret profits made by a partner or property acquired by a partner in breach of his duty of good faith. So the right option is option second. Question number 43. Mark the incorrect statement in relation to implied authority of a partner under section 19. The right option is wait. First one is a partner can always enter into partnership on behalf of firm. Second, a partner can acquire immovable property on firm's behalf or transfer immovable property, for example, sell, mortgage, lease, or gift belonging to the firm. Third, a partner can admit any liability in a suit or proceeding against the firm. Fourth, all are incorrect. So the right option is option 4, that is all are incorrect. Incorrect statement in relation to implied authority of a partner under section 90. Option 4 is the right option. Question number 44. In which of the following cases the specific performance of a contract is not possible? A specific performance of a contract is not possible. First, a contract to give in marriage. Second, an agreement by an eminent professor of constitutional law to deliver a course of lectures at the Delhi University. Third, a contract to supply B with all the goods of a certain class which B may acquire in future. Fourth, all of the above. The right option is option 4, that is all of the above. Question number 45, which of the following is incorrect? Which of the following is not correct? First option is the court shall not refuse. The court shall not refuse to any party specific performance of a contract merely on the ground that the contract is not enforceable at the instance of the other property. Second, the jurisdiction to decree. Second, the jurisdiction to decree specific performance is discretionary and the court is not bound to grant such relief merely because it is lawful to do so. Third, the ordinary rule is that a specific performance should be granted. Fourth, relief of a specific performance is not an equitable relief. The right option is option 4, that relief of a specific performance is not an equitable relief. Question number 46. A partnership firm consists of three partners A, B, and C, and owes R sum of rupees 15,000. A wants to retire, and it is agreed amongst all the three partners and R that after retirement of A, B, and C as continuing partners shall be liable for the dues of R. After the retirement of AR sues A for recovery of. After the retirement of A, R sues A for recovery of 15,000. R has an option to sue the firm consisting of B and C or the retired partner A. Second, R has a right to sue A to the extent of 5,000 being the portion attributable to A. Third, R has no right to sue A as after the retirement of a new agreement came into being between R and the firm, and A stood discharged of his liability toward R. Fourth, R can sue the firm consisting of B and C along with A as liability of all partners is joint and several. The right option is third, that R has no right to sue A as after the retirement of a new agreement came into being between R and the firm. A stood discharge of his liability towards R. Question number 47. X agreed to supply 1000 ton of iron at rupees 100 per ton to Y to be delivered not later than 31st January 2005. X also entered into a contract with A for purchase of 1000 ton of iron at rate of 80 per ton, telling A clearly that the iron is needed before 1st January 2005 for supply to Y to fulfill the contract with Y. A fails to supply iron to X, who in turn fail to supply the same to Y. In an action by X and A, X can recover damages for the loss of profit at the rate of 20 rupees per ton, that is the loss of profit. Second, X can recover damages for the loss of profit he would have earned by timely supply to Y, and also the damages which X might have paid to Y on account of breach of contract. Third, X can recover damages which X might have paid to Y on account of breach of contract. And fourth, X can recover damages in the form of penalty. The right option is first. X can recover damages for the loss of profit at the rate of 20 per ton, that is the loss of profit. Question number 48. A partnership for which no period of duration is fixed under the Indian Partnership Act 1932 is known as general partnership, partnership at will, particular partnership, or co-ownership. The right option is second, that is partnership at will. Question number 49. Where a partner is authorized to recover dues of the partnership and spend the same for the business of the partnership, and if he does not deposit the money so collected in the bank, the partner is first guilty of a criminal breach of trust, second accountable civilly to the other partners, third both first and second, fourth either first or second. The right option is third, that is both first and second. Question number 50. When an outsider dealing with a partner does not know or does not believe that he is contracting with a partner but an individual only, first, the firm incurs liability if the benefit of the contract has gone to the firm. Second, the firm incurs no liability even if the benefit of the contract has gone to the firm. Third, the firm incurs liability even if the benefit of the contract has not gone to the firm. Fourth, either first or third. The right option gonna be third, that the firm incurs liability even if the benefit of the contract has not gone to the firm. Wait. For question number 48, 48 partnership at will. Question number 49, where partner is authorized to recover dues of the partnership and spend the same for the business of the partnership, and if he does not deposit the money so collected in the bank, the partnership is guilty of criminal breach of trust and accountable civilly to the other partners. Both first and second are correct. Okay, in 58th question, when an outsider dealing with a partner does not know or does not believe that he is contracting with a partner but an individual only, believe that he is contracting with the firm incur liability if the benefit of the contract has gone to the firm. The firm incur no liability even if the benefit of the contract has gone to the firm. Its right option B will be option second instead of option third. नो लाइबिलिटी इसलिए क्योंकि फर्म से उसका कॉन्ट्रैक्ट हुआ ही नहीं, दोनों पार्टनर में हुआ, पार्टनर दूसरे पार्टनर ने इंडिविजुअली उससे जो है कॉन्ट्रैक्ट साइन किया उसके दूसरे पर्सन के साथ, तो फर्म का कोई रोल ही नहीं था, दैट्स वाई द फर्म इनकर्स नो लाइबिलिटी इवन इफ द बेनिफिट ऑफ द कॉन्ट्रैक्ट हैज गॉन टू द फर्म, भले ही बेनिफिट जो है फर्म को मिला हो या ना मिला हो. सो here it was 25 question, and we will continue discussing the remaining 150 question in our upcoming videos. Up till then, have a good time. See you.